Are we on the record, Madam Clerk?
Yes, we are.
Good afternoon. We'll be on the record. I'm Judge Kiley Stuchlik. I'm the District Court Judge assigned to this case. Today we're taking up the case of the State of Idaho versus Andrea Shaw, CR 38261685. We have Mr. Duke and Mr. Stuchlik present this afternoon on behalf of the state. We have Mr. Payette present this morning with his client, Ms. Shaw. This is the time set for district court arraignment on the indictment that was returned in this matter. There are two other matters that we should take up today. We've got the arraignment on the indictment, the motion for grand jury transcript that Ms. Shaw filed, and the motion for bond reduction. We'll start with the arraignment. Mr. Phillips, have you and your client received a copy of the indictment?
We have.
Ms. Shaw, have you had a chance to review the indictment?
Yes.
Ms. Shaw, you have a right against self-incrimination and to remain silent. You are not required to make any statement that might incriminate yourself. Any statements that you do make can be used against you in later proceedings. Do you understand?
Yes.
And the state has listed your name on the indictment as Andrea Shaw. Is that your true name?
Yes.
And Mr. Phillips, would you waive formal reading of the indictment on behalf of your client?
Judge, we would. She reads, writes, and understands English language, and we walk through the indictment.
All right, so we'll just summarize those charges for you. Count 1 of the indictment alleges first-degree murder with respect to DS. Count 2 of the indictment also alleges first-degree murder with respect to the child TS. Do you understand those charges, Ms. Shaw?
Yes.
Counts 1 and 2 both carry with them the same potential penalties. The charge of first-degree murder or felony is punishable by up to life imprisonment or the death penalty. It's punishable by up to a $50,000 fine, or both such fine and imprisonment or death sentence. It has a mandatory minimum of 10 years in prison, which must be fixed, and a minimum of life in prison. It allows the court to impose up to a $5,000 civil penalty in favor of each victim. The court cannot grant parole, probation, or withhold judgment. If you're convicted, a DNA sample and right home repression will be required. Do you understand those penalties, Ms. Shaw?
Yes.
If you are convicted of both of these offenses, the court can order those penalties to be served consecutively, meaning back to back. Do you understand that as well?
Yes.
Ms. Shaw, today you can plead guilty, not guilty, stand silent, in which case the court will enter a plea of not guilty on your behalf, or you can request some reasonable additional time before entering a plea. Ms. Shaw, how do you wish to plead today?
Judge, we're going to set aside entering a plea until a later time after this one. I would like to get my hands on grand jury transcripts before that time, if possible. I think that's 30 days.
I think 30 days, depending on the number of pages. Do you have any input on that, Madam Clerk?
One second. 30 days will be fine.
Okay, we'll complete you on the date set for the entry plea hearing. You have a right to a speedy trial. The state is required to bring you to trial within 6 months from the date you first appear before the district court, which will be today. So your speedy trial date would be January 14th of 2027. Okay, well then I guess it probably makes sense to just get you that entry plea date and then we can schedule pre-trial and trial at that next hearing. Does that sound good to the state?
It does, Your Honor. Thank you.
How about Tuesday, August 18th?
That works too. 1:30.
Does that work for the state?
It does, Your Honor.
Tuesday, August 18th at 1:30 p.m. For entry plea. Good, we can take up the motion for the grand jury transcript.
Your Honor, the state doesn't want you to do
And you were fine with the proposed order?
that.
Actually has a spot for you to sign it, and so why don't I just hand this to the marshal and hand it to you for review?
I will say, Your Honor, I did not see the proposed order for this. There's additional details in here that, well, there are deadlines in here that the state's not going to bind itself to. As far as splitting costs, the state's okay with that. But the state, also, I guess, we may have to have a hearing on that.
You may have to wait.
Have a hearing on that, because,
Certainly does, yes.
yeah, you're right. I think sort of, there are, we've crossed out parent 2 and parent 3, which simply put time limits on challenging language in the transcript. I think we've agreed now that the best way moving forward would simply get a copy, and then if we do have issues with the content or the actual transcript, then we can file motions afterwards. Or, all the procedural mechanisms we need to at that point. And so, so I'm going to go ahead and sign it. We did make those alterations.
Judge, I would say, I would like a copy of the transcript of the formation of the grand jury, and then the colloquy that occurred between the court and the prosecutor to set law.
Okay.
Yeah, I have no objection.
There's a spot for defense counsel as well. And maybe, Mr. Phillips, why don't you cross out those two provisions and initial that, and let's have Mr. Daniels do that as well.
You want to strike
That's what she said.
I've been handed back this order for grand jury transcript, pretty simple. And those changes to 2 and 3. Do you find good cause to order the transcript to be prepared? That will be a sealed copy of the transcript that will be provided to each party and will be used as set forth by the transcript order. We did have a court reporter present for the grand jury. Here in the courtroom. You can know from Madam Clerk to send this order to her as well. And the transcript will include the jury selection, proceedings of the grand jury, and the return of the indictment and bond argument. It will not include the deliberations, of course. All right. Anything further on the grand jury transcript issue, Counsel?
No, Your Honor, thank you.
from the defense.
Very good, then we can proceed to take up the issue of the motion for bond reduction. Mr. Phillips had a chance to review the motion that you filed back on July 2nd, the amended motion that you filed yesterday, your exhibits A through D, which I did grant the motion to file under seal. Those did contain personal data identifiers that should have been redacted by your children's names, dates of birth. Those are all subject to redaction under the Idaho Rules of Electronic Filing and Service 15B. And pursuant to ICAR 32, little I and 3, capital A, it is appropriate to seal those. However, I just want to let counsel know that I want to file ICAR 32 carefully, balance the public's right to know information with the provisions of that rule. So stating that something is confidential or that the public has no interest in it is not one of the factors set forth in ICAR 32. So please be sure to comply with that rule for any future motions. All right, there was also a couple of affidavits that were submitted. I had a chance to review those as well. I did have a chance to review the state's objection that was filed earlier today, I believe it was. So we can proceed. Do you have any additional argument you'd like to present today, Mr. Phillips?
Just very briefly, and just going through the amount of discovery that they provided, there's a lot of audios and videos as well that I cannot touch. But from a glean, the coroner has a different opinion as to the cause of death, as what the prosecutor's office thinks. This is certainly a case in search of a crime. It's not a crime in this case. I'm going to defend this case like she's not guilty because she's not guilty. It's not going to be a typical case. I just asked the court, after reviewing their evidence, I think release on their own recognizance would be even allowable in this case. But I'm not going to ask you to do that. I'm going to ask you to set a $100,000 bond with restrictions. And I think we've outlined everything in there for the court. Thank you.
Thank you, Mr. Phillips. Any response from the state?
Thank you, Your Honor. Your Honor, in this case, the defendant is not even entitled to bond. This is a death penalty case, or it's a death penalty potential, and as such, the court pretty much has unlimited discretion in how it decides to bond. In the Constitution and in the rule, it comments that the court can look at the strength of case. That's why we briefed it the way we did. Just to point out that the details of this case are extraordinarily alarming. The reality is when two kids die at the exact same time in the same house in the same bed, that the state takes an interest in that. And the reason I rehash some of these is because I want to point out that environmental causes, which is what the coroner was looking at, those were proposed early on. And as part of the investigation, they actually looked to see how hot the room got. It did get extraordinarily hot. The coroner looked at news articles, and based on news articles, thought that it was possible. We relied on the opinions of experts, doctors who take care of kids, and they ruled out heat, both because time of death doesn't work with the heat theory, because in order for heat to be the cause of death, it would have taken longer, and the children were in full rigor when they were discovered at 11:30, and so that takes about 8 to 12 hours, and in order for the room to get hot enough for the twins to experience that heat for long enough, then it would have died later. And the doctor does support the conclusion that suffocation is the cause of death, which we use in the grand jury, and which will be one of the state's witnesses. And both the children had pulmonary edema. Well, no, one child had pulmonary edema. Both children had pulmonary vascular congestion. These are symptoms consistent with suffocation, and the other part of this is that the court is allowed to look at the quality of the evidence or the quality of the state's case. In this case, the children died when there were two people home, and one of those people was the father, and he was asleep. His story was that he was asleep. It never changed. It was consistent. The second person said that she visited the children at 2 in the morning, which is about the time of the cause of death, and her story changed radically throughout this process. Her initial story, she said she got up with the children at like 8 o'clock in the morning, fed them breakfast, went through a whole routine. Then she backtracked from that, acknowledged it wasn't true, made a statement that she was like vivid dreaming or something like that, which is why she believed she had done that. But was emphatic that she saw one of the children sit up at 2 o'clock, or between 1 and 2, when she went to check on him after getting home from being out with a friend. And she was emphatic that the child was still alive and she had checked on him at that time. When law enforcement pointed out that that means that they had to have died when it was just the two of them in the house, she acknowledged that was bad for her, and then changed her story again to say that she didn't actually see the kid sit up after being emphatic that he had. And so what we have here there are only two possible people who could be involved in this crime. One of them was straightforward and cooperated with law enforcement. The other changed her story every time it made her look bad, every time there were criminal implications, and she admitted that at the time of death, she was there with the kids. And so the reality is this is not a vaccine case. I know that's been presented. The doctors, the people, the medical experts in the industry that we've talked to, anyway, do not support that theory. And so this is a case where a mother, unfortunately, has killed her two children. And the state's position is that letting her go, or making it easier for her to return home, as stated in the motion for bond reduction, so she can take care of her other kid, that child is the most at-risk individual as a result of this case and as a result of the defendant's actions and behavior. And that is the single highest risk factor that the state is looking to protect. We do not think she should be allowed to be anywhere near any children, let alone her own children, to take care of them. Because it was the other two children who were in her care that died at the exact same time, the same night after she got home from being out with a friend. And so the court, when it changes bond, is allowed to move it both up and down. The state's position, and after the grand jury indictment, the court did ask if she had any children or ties to the community. I didn't know she had just had a child. I answered that I didn't know that at the time. And I think the court gave a reasonable bond, frankly. I think $2 million is reasonable. Now knowing that she wants to go home and be with a child after knowing what these charges are, and seeing that, like, the circumstances of this case, the state would ask that bond actually be revoked. I think it's appropriate that she not be given bond, and at the very least, I think keeping it at $2 million is appropriate. If the court does give her bond, then I would request that she not be permitted to be around any children, and explicitly that she not be allowed to be with her own child, because that is the person that we worry the most in this case about, and that's the person she wants to get to the most. And so, as difficult as that is for any parent to imagine being separated from their kid, this case warrants it in the state's opinion and warrants it. Thank you.
If that responded,
You may go ahead, Mr. Belzay.
it's not the danger of the kid, it's ridiculous to me. If you look at our briefing and you look at our affidavits, you can see that for a week, she was trying to take care of kids who got sick from the vaccine. I don't have to prove it was a vaccine. That's our theory. The state has to prove beyond a reasonable doubt that she did something affirmative to kill those children. The state's position is, you have two people in the house with the children, it's gotta be one of the two parents. Well, they could die from something other than one of the two parents. And a vaccine reaction mimics suffocation. That's just flat out. So I would ask that you reduce the bond to $100,000. And with respect to this kid, she wants to be able to bond with this kid. The state's perspective that we'll deal with that in the next set of motions once we get the grand jury transcript. But this case is going nowhere.
All right, thank you, counsel. The issue before the court as to setting bail and the conditions of bail are issues within this court's discretion. Under Article 1, Section 6 of the Idaho Constitution, all persons shall have reasonable bail, except where proof is evident or the presumption is great in capital cases. This is a capital case. Under Idaho Code 19-2903, it contains that same standard with the exception of capital cases. The court is also considering the Idaho Bail Act, Idaho Code 19-2904, talks about the factors the court should consider, ensuring the appearance of the defendant, ensuring the integrity of the court process and the right to bail, ensuring the protection of victims and witnesses, and ensuring public safety. The court is also to consider Idaho Criminal Rule 46, which I have, which allows the court to limit bail for a person where the offense is punishable by death. The determination of whether a defendant should be released on the defendant's own recognizance or admitted to bail, and the amount of conditions of bail, if any, may be made after considering the factors set forth in Idaho Criminal Rule 46C. I have considered all of those factors. I did, upon return of the verdict, I did ask Mr. Duke about other children in the home. I didn't view Ms. Shaw as a general threat to public based on the court doesn't sit in on the grand jury proceedings, so I had limited information, but
from Mr. Duke's explanation that a medical doctor did testify and as to the cause of death. I did view her as a threat to any children in the home, but I did not view her as a general threat to the public. Ms. Shaw does have several factors in mitigation under Rule 46. Those would be her ties to the community, her lack of criminal history, her residence history, persons who agree to assist her in attending court. She does not appear to be likely to flee the jurisdiction. And the court could put some restrictions on her movement. However, of course, an aggravation would be the nature of the current charges to crimes both punishable by up to the death penalty or life in prison. So at the time that I decided to set the bail at $2 million, I was considering that, again, I didn't view her as a general threat to the public, that she had many factors in mitigation. And when the state was asked, they said they were not aware of any children in the home unless some had been born between the time of this incident and now, and they weren't aware of that. So that is new information to me. And so I've considered that. I do have concerns. I think that makes the factor about possibility of violations of law an aggravation for Ms. Shaw due to concerns for the new child safety. And again, under Idaho Code 1929-04, public safety, I think that factor has changed for the court as well since the time that the court initially set the $2 million bond. I know the defense has indicated that they will vigorously defend this charge, but I haven't seen any expert identified to testify on behalf of the defense. I do know that the grand jury considered expert testimony with regard to cause of death, so I do think that the proof is evident or the presumption is great. And with that additional information that the court now has before it, and the fact that in the court's view, Ms. Shaw does pose risk of safety to the other child who has been born recently, that I'm going to exercise my discretion to revoke bond. Now we are getting a grand jury transcript. Like I said, the court hasn't been able to hear the testimony that was presented before the grand jury, nor has the defense counsel. The court has discretion to reassess these factors, as the court did today. The court can do that in the future. And so, Mr. Felicetti, after you're able to review that grand jury transcript, if there's any information that you think the court should reconsider, you can certainly file another motion for the court to set bond, but that'll be my decision today.
Is it possible to get a full transcript of grand jury formation and the grand jury transcript quality digitally, so I can review that and get this expedited? With the seal, the same thing.
Your Honor, the state doesn't subject to releasing the document.
Then we can, I'll grant that motion, we can get you, perhaps the secret or something that's sealed with the FTR audio. All right, I've signed that commitment order.
You want me to give you an order, Judge, for that?
No, I filled out our kind of standard form. Council, anything further to address at this time?
Nothing for this video.
No, Your Honor.
Then, court will be adjourned.
Please rise.